Mr. Greenall.
Sir, thank you for the opportunity to make a closing statement on behalf of Lord Peter Hain, Professor Jonathan Rosenhead, and Ernest Rodker. I intend to follow the written closing which has been submitted to the inquiry, and I will not rehearse here all the detail which has been put in that written document. I will also try to pick up on some of the points that have been made by the other core participants as I go. Tranche 1 has heard evidence of shocking, unjustified and unjustifiable surveillance of anti-apartheid campaigners by undercover officers in the Special Demonstration Squad. Lord Peter Hain, Professor Jonathan Rosenhead, and Mr. Ernest Rodker invite the inquiry to reach robust findings in line with these conclusions. In their initial opening statement for Tranche 1, these core participants raised the following concerns over the targeting of political and social justice campaigns and the participation of undercover officers in protests and miscarriages of justice. Those were, number one, the unjustified and politicized nature of undercover policing. Number two, the lack of any effective system of checks and balances. Number three, the lack of any proper oversight. Number four, racial bias and racism within undercover policing. Number five, a culture of contempt and abuse towards the rights of those targeted, including gross disregard for breaches of fundamental human rights. All of these issues have been exposed in Tranche 1 of this inquiry. I turn now to the targeting of the anti-apartheid campaign. The core participants I represent have consistently raised two broad concerns over the targeting of anti-apartheid campaigns by the Special Demonstration Squad. First, there was no legitimate policing need to target these campaigns using undercover officers. Second, the targeting of those campaigns was influenced by political concerns. Turning to the issue of justification, there was no proper justification for targeting the anti-apartheid movement or the Stop the 70 tour or the other organizations campaigning against apartheid South Africa using undercover officers. The anti-apartheid movement was an entirely conventional campaigning organization which gave rise to no particular concerns over public order or subversion. While the Stop the 70 tour openly used non-violent direct action to further its campaign, this did not justify the use of undercover officers who infiltrate the organization. It is important to correct the record relating to the purported justifications for targeting the anti-apartheid campaign. Former undercover officers have claimed that these groups were involved in violence and disorder, and that this was the justification of the actions of the SDS towards them. These claims are false. From the outset, the Stop the 70 tour and the anti-apartheid movement were non-violent campaigning organizations. Violence was never part of their aims or their methods. Lord Hain, Professor Rosenhead, Ernest Rodker, and Christabel Gurney have all made statements confirming that this is the case, and it was confirmed in their oral evidence. Their position is supported by contemporaneous documentation about the aims and methods of the anti-apartheid movement. This was summed up by the undercover officer HN 298 in his witness statement as follows. There was nothing clandestine or revolutionary about the anti-apartheid movement. They were a group of people who did not think the situation in South Africa was fair. They wanted to make apartheid a high-profile issue so that people would say it was outrageous in the hope that things would change. It was not subversive, so as far as I was aware. I do not think they employed or approved of the use of violence. The Stop the 70 tour did engage in non-violent direct action. However, this went no further than minor damage to property and the disruption of events such as rugby matches. This was implicitly understood by those who took part. Any debate that is recorded in SDS records over the use of violence was effectively confined to the extent to which damage to property would be condoned by the STST. Violence against persons was never part of their aim. Much has been made by those in the SDS that HN 135, Mike Ferguson, occupied a close position to the leadership of the STST, being referred to as, quote, Peter Hain's right-hand man. Lord Hain continues to deny that HN 135 occupied any role that could be described in that way. Whatever his precise role was, he did attend STST planning meetings where few others were present. It is therefore telling that his reports about the STST's plans and methods do not, at any point, indicate or suggest that the STST supported the use of violence on demonstrations. I note in passing that it would clearly be impossible to attend such small planning meetings of a group such as the STST without taking on some sort of active role within the organisation. Tactics and proposals would inevitably have been discussed in these small groups, and those present would inevitably be drawn into such discussion. Therefore, the boundary between activity as a follower and as a leader does not appear to have been respected. The core participants repeat their refutation of the claim by HN 336 Dick Epps in oral evidence to the inquiry that he attended an STST demonstration at Twickenham at which instructions were given to, quote, attack the police. This is untrue. The allegation was made for the first time 50 years after the events and is unsupported by the contemporaneous documents. For the reasons set out by the core participants' opening statement for Tranche 1, Phase 2, the inquiry is invited to reject this part of his evidence in face of clear evidence to the contrary. It is submitted that it is not enough to claim that public order records and reports have been lost and that only a selection of reports remain. Instructions to commit violent acts do not feature in any documents that have been recovered by the inquiry. As Lord Haynes stated in his oral evidence to the inquiry, the STST was entirely open about its aims and methods. It was public knowledge that the STST sought to disrupt sporting events by attempting to enter the pitch. Against this background, there was nothing which required a policing response based on SDS officers seeking to infiltrate the STST. Any public order concerns that arose could have been dealt with using conventional policing methods and did not justify the activities of the SDS. The Met Police, by way of contrast, invite the inquiry to conclude that the SDS reporting into the STST assisted the policing of events. By way of example, they cite reports by HN 135, which set out, quote, basic tactics to be used by the STST. For example, they cite a report dated the 9th of December 1969, which related to the forthcoming Springboks match at Twickenham on the 20th of that month. The report stated that there would be, first, a mass demonstration outside the ground, secondly, protesters handcuffing themselves to goalposts, and thirdly, an attempt to gain employment at a hotel where the Springboks were staying. In response, we submit that in reality, there was little information of use to public order policing that was not already well known. That there would be a mass demonstration outside the ground was easily predictable and had been stated publicly. That people would try to disrupt the match and try to get onto the pitch was obvious, and again, publicly stated by the Stop the 70 tour. There was no need for undercover officers to establish that information. The specifics of how persons would seek to get onto the pitch was not so important. It's unclear how the fact that handcuffs might be used is of such great relevance in terms of public order policing. And in relation to direct action at a hotel, it's submitted that this doesn't create any significant public order issue. Similarly, the Met Police rely on a report about the Stop the 70 Tour National Conference on the 7th of March 1970, which included details of plans to demonstrate at all places where the South African team were assembling, the first big demonstration to be held in June, and other locations were listed. Again, it's submitted that it was obvious that the Stop the 70 Tour would seek to demonstrate wherever the South African rugby team assembled. The dates of the big demonstrations were easy to find out with conventional methods, so it is unclear how much assistance to public order policing this report contributed. It is important to note that it was only disruption to the large matches that had any real public order concerns. Smaller roadblocks at team hotels and the like were certainly not on the same scale. Of course, there was an element of surprise to the STST tactics, but that concerned the specifics of how a match would be disrupted. That the STST would seek to disrupt the matches primarily by getting onto the pitch was very well known, and the specifics of how that was to be done were less important for policing purposes. Therefore, the utility of the SDS to the policing of the large STS demonstrations was minimal and certainly did not justify the methods employed by the SDS. I now move on to the issue of disproportionate reporting. The inquiry has seen evidence of very widespread recording of personal and private information about the court participants, which went well beyond any conceivable public order concerns. In relation to Ernest Rodker, reports were filed and sent to the security services containing personal information irrelevant to any public order concerns. These included the fact that he and his wife had had a child, the fact that he had been unwell and was in hospital. Similarly, undercover officers reported the presence of Peter Hain's younger sisters, both still children at the time, at meetings of the Young Liberals in his parents' home. Again, this information was copied to the security service. And this information is not unusual, but in many ways is typical of the sort of information collected. Beyond their involvement in the anti-apartheid struggle, there are numerous reports relating to the court participants I represent attending public meetings of an entirely conventional political nature. These are meetings which should have been free from state surveillance. In 1975, an intelligence report is made of a public meeting held by the Battersea Redevelopment Group, attended by 150 people, including Ernest Rodker. That meeting is simply part of a local campaign relating to redevelopment of a fun fair, attended by residents and local politicians. Again, it is concerning to note that the information is sent to the security services. An SDS intelligence report from 1980 also lists the names of people identified as being present outside a conference centre, Wembley, Middlesex, where the Labour Party is holding a special conference. Peter Hain attended that conference in his role as a delegate from the Putney Labour Party branch, and he took his two sons to the creche there. There is simply no legitimate reason for the SDS to collect this data. We submit that the opinion of undercover officers towards their managers in relation to the collection of personal information can be seen in the oral evidence of HN 298. Referring to the views of the office and admin and people in charge towards his attendance at meetings in the front room of Peter Hain's family home, where Peter Hain's sisters were recorded to be in attendance, HN 298 said, I think probably in relation to this kind of thing, they're actually too frightened of these things. They happen and they're confronted with them, and they don't really want to make waves. And this is how these things work. They don't want you to make waves, but when they're confronted with it, they're in essence obliged to go along with it. It's important to note that when SDS managers did seek to provide direction on tasking, many SDS managers state that decisions came from outside the SDS, either from C Squad in Special Branch or either directly or indirectly from the security services. As former SDS manager Jeff Craft stated, the branch was the legs of the security service. So the picture presented is of SDS officers adopting an unfiltered approach to the recording of private information, the managers taking a reactive approach to what was recorded and feeling obliged to go along with it for fear of making waves. And when they do seek to influence the tasking of officers, it is subject to inappropriate influence from the security service. In any event, no proper justification has been provided for the type of personal information which was collected by the SDS on the court participants. The means of collecting such information often involved entering their family homes by deception. It served no legitimate policing purpose, and there was no legal foundation for collecting the information. And the inquiry is invited to find that it should not have been recorded. I turn now to the topic of political influence on SDS tasking and operations. Documents disclosed in Module 2 from the Cabinet Office, records, demonstrate that concerns that were raised at the highest political levels over the anti-apartheid movement and Stop the 72 campaigns. And it appears that SDS reports were provided to meet these openly political influences. There were a number of secret committees formed at the highest levels which focused on subversion. These included the Official Committee on Subversion at Home and a variety of others. Many of those who sat on the committees had knowledge of the SDS, and the committees also sought to promote the gathering of intelligence on groups with which they were concerned. And these committees played a keen interest in both the anti-apartheid movement and the Stop the 70 talk. Minutes of the Committee on Subversion at Home meeting on the 21st of March 1970 contain a detailed report on the planned STST demonstrations. And it ends with the statement that, quote, the security service would keep in close touch with the Home Office in order to advise on the deployment of police resources at demonstrations. Similarly, notes for the 10th of March 1970 state, Sir Burke Trend may like to ask the Home Office and the Security Service for an up-to-date report on the cricket tour prospects and the development of measures to contain demonstrations. And that is accompanied by a briefing note entitled Stop the 70 Tour Committee, which gives details of the national conference held in March of 1970. And that is the conference that was attended by Mike Ferguson in his role as an SDS officer. Again, that report was provided to the security services and appears that information has been passed on to the Subversion at Home Committee. Now, there is debate in the Cabinet Office records over appropriate definitions of subversion, and some of the minutiae of the proposed definitions is gone through. But what is clear from the definitions adopted is that they are not limited to those who use unlawful means for achieving their aims, or those which actually or potentially posed any sort of threat to the British state. Irrespective of the particular definitions of subversion, what does not appear to have been considered is why the Security at Home Committee was taking such a keen interest in the Stop the 70 tour and anti-apartheid protests. These were campaigns which were focused on ending apartheid in South Africa. They did not have any intention to overthrow the British state on any definition of subversion, even on the wide definitions adopted by some of the committees. Similarly, if the definitions of Lord Denning or Lord Harris were adopted, there is no basis on which the STST and the anti-apartheid movement fall within the remit of the various subversion committees. There is hence no legitimate reason why the SDS should have been involved in providing reports on the STST to those committees. The fact that a request for targeting was made to Special Branch by the Security Service did not provide a lawful basis for complying with it. If the request for targeting fell outside the policing remit of Special Branch, then the police officers were obliged to refuse to comply with it. That is, the details of that are set out in the written version of this closing statement. But it is quite clear that very little questioning was taken by Special Branch to requests for information from the Security Service, and they were more than happy to go along with requests for information in relation to the anti-apartheid movement and the STST. It is clear that as well as the Home Office and the Security Service, the Foreign and Commonwealth Office were represented on the various committees in relation to subversion. Given the committee's interest in the anti-apartheid movement, this raises questions over the extent to which the government's interests abroad influenced the focus of the Subversion Committee, and in consequence, the provision of information from both the Security Service and Metropolitan Police Special Branch, and ultimately the SDS. And these issues tie in with concerns that have been raised by the court participants throughout the inquiry. Documents from the Cabinet Office now show the influence of Cold War anxiety about communism informing the motivation of the security services. The records show a pervasive concern with communism, which spread into other areas of alleged subversion. There were a myriad of different committees, all of which emphasized a policy of secrecy, as the minutes of the first meeting of the official group supporting the Ministerial Committee on Subversion state, and I quote, "The existence of these groups, both ministerial and official, should in no circumstances be allowed to become known. The trend in expanding coverage of these groups is summarized in a report relating to the Information Research Department which dates from 1974. And I set out the quote in full in the written document, but it states that over the years, the unit has evolved an expertise in viewing the subversive threats in their context and seeking to counter them by disseminating factual material to carefully selected recipients. And it goes on to talk about the broadening of the movement from 1969 to embrace all domestic subversive activities. The section now also watches such activities as those represented by student protests, Black Power, terrorism, and Irish extremism. Lord Hayne has repeatedly emphasised in his evidence that the British state's response to the anti-apartheid movement must be viewed through the perspective of the Cold War. As he stated in his oral evidence to the inquiry, the Cold War prism through which the anti-apartheid struggle was seen was a very big part of the context in which we worked, but it was the South African apartheid state that presented itself as a bulwark against communism in its own language. And it suited its purposes that Washington and London and Berlin and Paris and Rome saw it as part of a contest between the Soviet Union and the democratic West, saw it as being on the side of the democratic West, when in fact it wasn't a democratic regime, the very opposite. It went against all the principles of democracy, including not having a democracy because the majority were not allowed to participate or vote, and were denied the most elementary human rights. Lord Hayne has provided the inquiry with a special branch report from 1970, which is entitled The Final of a Series of Reports Regarding the Stop the 1970 Tour Committee. The report refers to, quote, discrete inquiries into Hayne's background, end quote, and makes a number of false claims, including that his mother was, quote, one of the leading members of the South African Communist Party, and that his father was, quote, active in the South African Communist Party, and that Lord Hayne himself was, quote, closely associated with the South African Communist Party. As Lord Hayne stated in his witness statement, it is clear that this information must have been provided by the South African Security Services, the South African Bureau of State Security, targeted groups campaigning against apartheid, both inside and outside South Africa. They were active in London in the 70s and 80s, and targets included the ANC and the anti-apartheid movement. This document, when viewed alongside the interests of the committees referred to in the Cabinet Office records, illustrates the clear liaison and influence between the UK Security Service and counterparts in South Africa, the product of which fed into special branch reports. The anti-apartheid movement in the UK was, of course, part of a worldwide campaign and sprang from the anti-apartheid movement in South Africa, including the ANC. Christabel Gurney, OBE, has provided the inquiry with details of how the movement was targeted in the UK, including a series of break-ins in the 1960s, the theft of membership records from the anti-apartheid movement's office in the early 1970s, and an arson attack on the anti-apartheid movement office in the 1980s. These incidents should be viewed alongside the bombing of the ANC's London office in 1982. The South African angle of some of these matters were explored in the report to the Truth and Reconciliation Committee in South Africa. The Cabinet Office records show a continued interest in actions taken opposing the apartheid regime in South Africa. In this context, the potential for influence on SDS targeting by the interests of the committees on subversion cannot be ignored. The Cabinet Office records also provide a historical link with state surveillance before the SDS era. There are similarities in the SDS targets from 1968 with groups that were of interest to the security services from the 1950s onwards. Anti-militarism and peace campaigns from the 1950s and 60s were of interest to the predecessors of the Committees on Subversion. And there is reference to the Committee of 100 being a target for the security service in a paper dated 1967, and a note from the Secretary of the Official Committee on Communism. Ernest Rodker was active in the Committee of 100, and it is notable that in documents relating to Ernest Rodker's prosecution at the Star and Garter demonstration, which I will refer to later, he is described by MD Roger as follows, quote, "This man Rodker has been a thorn in the flesh for several years now, having had no fewer than 14 court appearances prior to 1963 for offences involving public disorder. The continuity of interest from the committees on subversion and their predecessors suggests the explanation of why he was targeted in the SDS era and why he appears to have attracted so much attention, including reports, as has been stated, on his involvement in conventional campaigning groups and the collection of personal and private information about him." The Subversion at Home Committee records also show a keen interest in student demonstrations. The London School of Economics is specifically mentioned in a Security Service memorandum from 1970, provided to the Subversion at Home Committee. And I quote here, "Firms and individuals with investments in South Africa have been under attack for a long time. It will be recalled that this was the issue that first started the troubles in the London School of Economics, and the issue has had new life breathed into it by the Springboks tour and the forthcoming tour of the South African cricket team this summer." Professor Rosenhead was an academic at the London School of Economics at the time. The particular interest of the Subversion at Home Committee in student demonstrations therefore provides a motivation for his targeting by the SDS over and above his involvement in the Stop the 70 tour. It is notable that several SDS reports concerns meetings that were held at Professor Rosenhead's office in the London School of Economics. Again, this suggests an influence from the committees on subversion on SDS targeting. It is also clear that even when the formal targets of the SDS had moved on from the anti-apartheid campaign and the Stop the 70 tour, the anti-apartheid movement remained of interest to the Security Service. The SDS were aware of this interest and appear to have been collecting information on the anti-apartheid movement, sometimes on behalf of the Security Service, well into the 1980s. The political interest shown in the Cabinet Office records adds a further dimension to this influence. The influence of the committees on subversion on the SDS and its targeting is also evident in groups other than the anti-apartheid movement. For example, the Workers' Revolutionary Party and its predecessor, the Socialist Labour League, are referenced throughout the Cabinet Office records. Repeated reference is made to connections between the WRP and the entertainment industry. Documents record that the WRP has attracted to it a small number of talented writers, directors, and producers whose abilities are exploited in its interest. In television drama, members of the WRP produce work containing elements of Trotskyist propaganda. At the same time, the WRP has a wide range of contacts in the media through whom Trotskyist influence may be brought to bear in the reporting of news and current affairs. It is important to clarify that the work produced by the WRP members was emphatically not Trotskyist propaganda. The professional credentials of those WRP members working in film and television was of the highest order. The professional work they produced consisted of high quality and imaginative films and television dramas, the content of which was determined on artistic merit alone. The quality of their work was often given full recognition from independent critics and award bodies. And the written statement of Roy Battersby sets out examples of the sorts of awards and recognition which he in particular received. The same documents from the Cabinet Office also refer to the exclusion of subversives, or so-called subversives, from the higher ranks of the civil service. The concerns and methods of the committees on subversion are mirrored in the concerns of Roy Battersby, who, as knows, is a film director and was a WRP member, and who was blacklisted by the BBC, as outlined in his evidence to the inquiry. The WRP was well recognized by the SDS as not using violence and not being a threat to public order. It was clearly not a subversive organization, standing general election candidates, for example, However, it was nevertheless targeted by the SDS, despite misgivings by some managers. Indeed, in 1979, DCI Mike Ferguson, who was then a senior SDS officer, stated in response to a security service request for coverage of the WRP, and I quote, "Although the WRP was not considered to be a law and order problem, nevertheless, he was ready to put a source into the WRP if this would legitimately act as a stepping stone for penetration of an SDS target." It was clear that the SDS was involved in targeting the WRP at the behest of the security services for reasons unrelated to any proper policing purpose. The continued interest in the WRP by the committees on subversion further confirms the political influence on SDS targeting. And finally, in relation to the WRP, it's worth examining some of the actions of the SDS in relation to the WRP in closer detail. For example, it is known that HN 298 Mike Scott attended the WRP Education Centre, White Meadows, in February of 1976. And this was contrary to the wishes of Deputy Assistant Commissioner Gilbert and HN 3030 Peter Collins. The purported explanation for his attendance at White Meadows, contrary to his authorization, was that there was not time to communicate the withdrawal of the authorization to him before he attended, on the basis that he was invited to attend at short notice. This explanation was criticized by Liz Lester in her oral evidence, who explained that WRP members invited to attend White Meadows would regularly decline to attend at short notice due to work, family, or other personal commitments without attracting any undue attention. In short, the cancellation of the authorization should have been communicated to HN 298 before leaving for White Meadows, and had this happened, he could easily have withdrawn from attending without attracting any adverse attention. It's regrettable that due to the late addition of Liz Lester as a witness and her lack of core participant status, this point could not have been put to HN 298 when he gave evidence. The White Meadows Conference Centre was also previously subject to a police raid in September of 1975. A Home Office paper written in 1980 describes this as a raid on the Workers' Revolutionary Party on the advice of the Security Service, but much against the advice of the Metropolitan Police Special Branch. The raid was covered by the Observer newspaper, who had been tipped off prior to the raid occurring, and a printed report critical of the Observer printed a report critical of the WRP. There are clear parallels with the references to the use of adverse media coverage against purported subversive organizations as recommended by the Committees on Subversion. The context of the raid on White Meadows is described in Roy Battersby's witness statement. It is important to consider the wider picture, which we now get from the Cabinet Office records, in particular the Committees on Subversion. The Cabinet Office records confirm concerns over entryism and Labour MPs by the WRP around the time of the raid. This ties in with SDS reporting by HN 298 in the East Ham sub-district of the WRP in 1975, which addressed a campaign to oust the sitting Labour MP, Reg Prentice. The Cabinet Office also confirmed that, quote, dissemination and leakage of information was a recognised method of counter-subversion. We can then see special branch documents which show that there were meetings between the editor of the Observer newspaper and special branch in the days before the White House raid. The newspaper was tipped off about the raid before it took place. This led to a campaign by the WRP around the raid and the Observer reporting. Importantly, the timing of the raid came just before the 75th Labour Party conference, at which Reg Prentice MP was due to make a speech against his deselection by his local party. In this wider context, the political influence on the SDS operations take on a far more significant role. What the reports from the Cabinet Office records show is the level of political interest in many of the groups targeted by the SDS, particularly in circumstances where the SDS was ultimately dependent on the Home Office for funding. This gives rise to very real concerns over political influence on SDS targeting. In concluding this section on political targeting, I wish to return to those groups campaigning against apartheid and for racial equality more widely. In response to criticism of targeting of the anti-apartheid movement, both the Metropolitan Police and the designated lawyer group have stated that the police were required to remain neutral in political matters. As the designated lawyer stated in his closing statement on Monday, the right to demonstrate peacefully is a right of all citizens, whatever political view, unless they are prescribed organizations, and that the police were obliged to treat the far left and the far right in the same way. I wish to make 3 points in response. First, as a matter of law, there is no equivalence between freedom of expression for political opinion and hate speech. Many of the opponents of the anti-apartheid movement and Stop the 70 Tour, and later the Anti-Nazi League, were seeking to uphold an avowedly racist system of government perpetrating gross abuses of the human rights of the majority Black population of South Africa. Similarly, far-right groups opposed to the Anti-Nazi League were espousing racial hatred. The principle of the lack of equivalence between political speech and hate speech finds its modern expression in the European Convention of Human Rights and the limits of Articles 10 and 11 in relation to hate speech and actions with violent intent. But even looking at domestic law at the time, under the Race Relations Act 1965, promoting racial hatred was a criminal offence. Therefore, where the conduct of those who were opposed to people campaigning on issues of racial equality fell within hate speech, it simply lacked the legal protection that is granted to the anti-apartheid movement, the Anti-Nazi League, and others. Second, as a matter of fact, the SDS did not appear to concern itself with ensuring political neutrality or avoiding taking sides in a dispute. There are few documents from the SDS that suggest that this was a factor which entered into the consideration of the SDS in deciding whether to target the anti-apartheid movement or how far such surveillance should go. Putting forward the suggestion that the SDS was required to remain politically neutral as a reason why the anti-apartheid movement was targeted, or why there were no limits put on the infiltration of the anti-apartheid movement or SDST, is an ex post facto justification that is not reflected in the contemporaneous evidence. And third, and most importantly, this line of argument that the police were required to remain neutral simply ignores the fact that the SDS was already highly politicized in its targeting. It is that the clear line of influence from the Cabinet Office, Committees on Subversion, through the security services to Special Branch and the STS show a clear political influence in its targeting and its work. There are repeated references in the Cabinet Office documents to concerns about protests targeting firms and businesses with South African connections. There are no countervailing concerns raised about the need for the British state to stand up for racial equality and to combat racism. There are no countervailing concerns raised about the targeting of the ANC and the anti-apartheid movement and those campaigning against apartheid South Africa. The response by the Metropolitan Police on the reliance on police neutrality is therefore as follows. If only the SDS had been politically neutral, then we would not have seen them targeting groups in the manner that they did. The core participants repeat what was said in their opening statement for Tranche 1, Phase 2. The targeting of groups campaigning against the South African apartheid regime appears hard to justify because it is hard to justify. This is not simply a present-day perspective. It was unacceptable conduct, even judged by the standards of that time. These were political campaigns on issues of worldwide significance. They deserve to remain free from the influence of undercover police officers. The decision to target Lord Peter Hain, Professor Rosenhead, Christabel Gurney, OBE, and Ernest Rodker for surveillance as they campaigned against apartheid and to approach what they were doing as a threat to public order, democracy, and British society was a political choice, and involved the SDS taking a political approach to its work. In doing so, the SDS made a serious and grave error in the way it treated the anti-apartheid movement. This inquiry should confirm that error as a matter of historical record if there is ever to be confidence in a surveillance system that went badly awry, and to ensure similar errors do not occur in the future. So I intend now to move on to cases of miscarriages of justice, and principally the Star and Garter prosecution. On the 17th of January of 2023, more than 50 years after they were first convicted, the Crown Court at Kingston upon Thames upheld the appeals brought by Jonathan Rosenhead, Christabel Gurney and Ernest Rodker for offences arising out of the demonstration at the Star and Garter Hotel in 1972. These appeals followed the inquiry's referral of the matter to the panel considering cases of miscarriage of justice, who then made an onward referral to the Criminal Cases Review Commission, who in turn referred the case to the Crown Court. The court participants welcomed the chair's referral of the Star and Garter demonstration to the panel over concerns that the prosecution constituted an affront to justice. They endorsed the chair's comment that the prosecutor and the court were deliberately misled about HN 298's identity and role in the events which it was considering. Referrals from the Criminal Cases Review Commission to the Crown Court operate as a rehearing. Given the age of the case, it was clearly impossible for the Crown Prosecution Service to prosecute the appeal, and the appeals were allowed without the Crown Court being required to make any factual findings. However, when allowing the appeals, His Honour Judge Lodder, King's Counsel, stated in open court that, quote, "It is important to recognise that in the judgment of the CCRC, there were substantial grounds for finding an abuse of process. We do not resile from that in any way whatsoever." It is regrettable that none of the others convicted at the Star and Garter demonstration appear to have been contacted by either the inquiry or the CCRC. These remaining convictions appear to be unsafe, just like those that have already been quashed. Moreover, the court participants are unaware of any attempt to correct the record of conviction from Mortlake Magistrates Court to replace the false name given by HN 298, which is known to refer to another person who is still living. With HN 9, it should of course be replaced with HN 298's real details. It is submitted that as well as referring the convictions of Rodker, Rosenhead and Gurney to the panel, it is important for the inquiry to consider the following matters when assessing the issue of miscarriages of justice within the inquiry's terms of reference. I do not intend to repeat the detail which is provided in the written document. I will simply give the headline points. The first is the factual innocence of those who were protesting at the Star and Garter. The second is the lack of prior authorization to HN 298 to participate in the demonstration or any demonstration of that type. The system of authorization, both at a particular and general level, was entirely ineffective, if not non-existent. Third concerns the lack of disclosure of HN 298's true role. Fourth is misleading the court. Fifth is breach of legal privilege. The court participants also asked the inquiry to make findings concerning the role of SDS management in the decisions that led to the Star and Garter prosecutions. Even a cursory examination of the evidence shows that the matters referred to above were done with the full knowledge and even encouragement of the SDS management. Again, I don't propose to rehearse the details which are in the written submission, and simply to note that the Star and Garter matter was referred to Assistant Commissioner level within the Metropolitan Police within days of arrest and charge. Far from being critical of HN 298, senior management praised his, quotes, refreshing initiative. The court proceedings were considered by the management in a memo in which the only concern raised was, quotes, embarrassment to the police if his true identity should ever be disclosed, end quote. It appears that the Metropolitan Police have managed to avoid such embarrassment until this inquiry began to look into matters. Court participants submit that the management at all levels within the STS and the higher ranks of Special Branch were aware of and approved the plan for HN 298 to participate in criminal proceedings without disclosing his true identity. It is further submitted that no concerns were held by STS managers over misleading the court, breaching legal privilege, or for any other consequence beyond reputational damage to the police. And the inquiry is respectfully invited to make relevant findings in line with these submissions. So I turn now to issue of later prosecutions. And as submitted in the opening statements for earlier phases of Tranche 1, the Star and Garter prosecution set the template for the policy of total secrecy around the involvement of undercover officers in the criminal justice process. The policy against disclosure and the lack of concern for legal privilege also appears to have been embedded in the Tradecraft Manual. Similar concerns about a lack of disclosure to defence and prosecution can be seen in the prosecution of HN 13, Desmond or Barry Loader, in 1977. And I set out details in the written submission about 2 occasions on which he was arrested and prosecuted for public order matters. On both occasions, the documents show that no disclosure was made to the defence or prosecution that an undercover officer was involved in the case in any way. What is disclosed in the documents is that a court official appears to have been told that HN 13 was an informant that the police wished to safeguard from a prison sentence. However, seeking a reduction of sentence for an informant on the basis of assistance given to the police is very different from disclosing to the court that a defendant currently facing trial, alongside others, is in fact an undercover police officer, and it does not remedy the integrity of the trial process. It's against these documents that the oral evidence of HN 34 Jeff Craft must be assessed. HN 34 signed off 2 reports relating to the prosecution of HN 13. Later documents postdate his time in the SDS. In his written Rule 9 statement, HN 34 denied any recollection of the prosecution of HN 13, stating explicitly, "I have no recollection of this at all. I do not remember going to court for HN 13. However, shortly before the oral hearings, HN 34 indicated that he did recall the incident. No further witness statement was provided, but in oral evidence, he stated that he briefed the magistrates that HN 13 was an undercover officer working in his undercover name, and that it was a secret operation, and that he would maintain that name, presumably in the court proceedings. And he states his concern was because he was arrested with other people who like to make public display, and there was a chance he might pick up in the dock and behave badly, and would be obliged to maintain his cover to join in with that. Again, the details are provided in the written document, and I don't propose to rehearse them here, but it is notable that the oral evidence of HN 34 was only given following opening statements where submissions were made that disclosure to a court official, as set out in the written documents, fell short of what was required to ensure a fair trial. It is also clear that the oral evidence of HN 34 has the following weaknesses. First, it's unsupported by contemporaneous documents. There is no reference in the contemporaneous documents that a magistrate was told anything about HN 13's true role. The chronology provided by HN 34 does not appear to match what is set out in the written documents. The number of court officials spoken to, again, does not match what is set out in the written documents. The content of the disclosure does not match what is set out in the written documents. The written documents refer simply to a court official being told HN 13 is an informant. In fact, in relation to one of the prosecutions, it states that the defendant was not particularly identified as amongst the group of defendants before the court. Fifthly, the motivation for this disclosure provided in oral evidence does not reflect what's in the written records. And sixth, the general level of recollection of HN 34 of events does not appear to be strong. Doesn't appear to be able to give evidence about any other matter other than his statement that he recalled speaking to a magistrate. The fact that this evidence came late in the day without any updated written statement has meant that there has been a limited opportunity in order to test his recollection. But for the reasons given in the written document, the inquiry is invited to reject the oral evidence of HN34 that a magistrate was told that HN13 was an undercover officer. In any event, there is no evidence that any magistrate was spoken to in relation to the later prosecution of HN13 at Camberwell Green Magistrates Court. In relation to this, all the written documents refer to are that a court official is told. In relation to both prosecutions, it's clear that no disclosure over HN13's role was made to the prosecution. There was hence no means for the prosecution to consider whether there was other material which would have fallen to be disclosed to the defence if they had been aware of HN13's true role, or to consider the public interest in continuing the prosecution. And this is particularly concerning in relation to prosecution for charges that appear to arise from incidents involving excessive force from uniformed officers. In any event, it is not accepted that informing a magistrate, even assuming this was the trial judge, that HN13 was an undercover officer, is sufficient disclosure to ensure a fair trial. The court was not told whether HN13 was going to go on to give true evidence, or whether what he said in court would be a continuation of his undercover role. This has, again, particular significance in relation to the context of offences arising from excessive force by uniformed officers. So the disclosure given in the manner suggested by HN34, it is submitted, is not sufficient to remedy the integrity of the trial process. Stepping back in the details of what was said to the court officials in these cases, what is clear is that the only concerns raised by the managers in the STS are over maintaining operational secrecy of the STS and protecting HN13 from a prison sentence. No concerns are raised by anyone in relation to the fairness of the court proceedings or the impact on the co-defendants who, assuming the STS managers' fears for HN13 were correct, appear to be facing a real risk of imprisonment. This focus is shared by HN34 in his oral evidence. But whatever he said to the court, his motivation is simply to protect HN13 and not over ensuring the integrity of the trial process. Again, the fact that an undercover officer was facing criminal proceedings was communicated to very senior managers within Special Branch. Again, details on in the written closing, but the matters were communicated right up to the Commissioner of the Metropolitan Police. At all stages, the only concerns raised are for the well-being of HN13 and maintaining the secrecy of the SDS. No concerns over any other aspects of the criminal justice system. These findings are mirrored in the review of possible miscarriages of justice carried out by Mark Ellison QC and Alison Morgan in 2015, as they say that they have seen nothing to indicate during the era from 1968 to 1989, when the Home Office funded the SDS, that the potential impact that the policy of total secrecy might have on criminal prosecutions of activists was ever considered. So the picture emerging from the evidence of Tranche 1 is that SDS management are aware of undercover officers facing criminal charges, but then actively promote and support the policy of total secrecy without regard for any impact beyond the SDS itself. The policy of total secrecy had the capacity to erode faith in the criminal justice system. It was a template set down by the prosecutions considered in Tranche 1 and picked up in later decades. It should be a central concern of this inquiry. Not all the identities of those defendants prosecuted alongside HN13 have been made public. Whilst these convictions were subject of a short report by the CPS for Operation Shea, no referral of the convictions appears to have been made to the CCRC. The court participants ask that the convictions are referred for consideration by the panel considering miscarriages of justice. I now wish to make a few brief statements in conclusion. And in concluding the call participants returned to the questions which they invited the inquiry to address in their initial opening statement. And these are: what was the purpose of the surveillance on them in the first place? Was the purpose legitimate? Even if one of the purposes put forward was ostensibly legitimate, was there a different, illegitimate, and true purpose? Was the purpose tainted by political motivations? Was it tainted by racism or other prejudices? Is the purpose that is now being presented no more than an ex post facto justification? And was the purpose even clear at the time? 2, was there an appropriate legal and supervisory framework for that surveillance? That includes, what was the framework? Is there any evidence of the framework at the time? Was the framework followed? How was the legal and supervisory framework avoided or exploited by officers and supervisors? And why did the framework not fulfill its purpose to protect the rights of these core participants? Thirdly, was the activity carried out pursuant to the surveillance necessary and proportionate? What threat, if any, what was the threat, if any, posed by those placed under surveillance? And was the level of intrusion or the unlawful activity pursuant to that surveillance justifiable? Following the hearing of evidence in Tranche 1, the core participants submit that the answers to these questions in the Tranche 1 era are clear. 1, there was no legitimate purpose behind the surveillance of these core participants. 2, the legal and supervisory framework was wholly inadequate, if not non-existent. And 3, the surveillance activity was a grossly disproportionate interference with their private lives and legitimate political campaign. Sir, thank you very much, unless I can be of further assistance.
Thank you very much for your submissions. You've come comfortably within the time that you allowed yourself. Thank you. We will now resume at 3:10 from Wales with Ms. Heaven. Ms. Heaven,
Good afternoon, sir. I just unmuted myself.
I'm afraid you've got the graveyard slot. You were the last submission
like
on
that.
the last day of the submissions.
Yes, okay, thank you very much. So these oral closing submissions are made to assist you in preparation of the Tranche 1 interim report. They are made on behalf of the cooperating non-police, non-state core participants who have expressed a view on these matters. Detailed written closing submissions have also been submitted and will be published shortly on the inquiry's website. The written submissions, of course, deal with the evidence in much more detail than I can cover today. So for over 40 years, the Metropolitan Police Service and the British government remained silent and actively sought to keep hidden from public scrutiny the unlawful, illegitimate and anti-democratic system of state-sponsored espionage that was carried out by British police officers across the United Kingdom. The fact that for decades the police were engaged in politically motivated policing that primarily targeted the left was an embarrassment and hence a closely guarded secret. The abhorrent practices that took place were only brought to public attention when the courageous women deceived into sexual and close personal relationships with undercover officers, exposed those officers and spoke about what had happened to them. It is important, sir, that you publicly acknowledge these facts and record that it was the actions of courageous individuals rather than the state that allowed the truth about the unlawful activities of the SDS to be exposed. Since then, those affected by undercover policing, which is not just limited to the non-police state core participants, have faced an unrelenting fight for truth, justice, and accountability. They have faced resistance from the state and policing institutions at every stage. There has been a deliberate and concerted attempt to prevent the public and the non-police state core participants from understanding the true extent of the state's wrongdoings, whether it be through the suspected destruction of evidence, restricting disclosure, or an apparent refusal to tell the truth. Every investigation to date has either been frustrated or resulted in inadequate, incomplete, and unsatisfactory conclusions. It should not be forgotten that the Metropolitan Police Service have failed to disclose vital incriminating information on their police spying operations to another public inquiry, the Macpherson inquiry. The facts under investigation by this public inquiry are a national scandal. The devastation caused by what occurred during the Tranche 1 era and beyond must not be underestimated. Lives have been destroyed, identities have been stolen, individuals have faced a lifetime of unemployment and poverty, those seeking justice, including against the actions of the state, have been undermined and the legal system has been damaged. There have undoubtedly been numerous miscarriages of justice and public trust in policing has been broken. The damage continues. Thousands of individuals have had their most private activities reported on and their data stolen by the state. When on the 6th of March 2014, the then Home Secretary Theresa May announced this public inquiry to Parliament, she felt able to clearly assert that what had been discovered about the SDS was profoundly shocking and, quote, will be of grave concern to everyone in the House and beyond. The non-police state core participants agree. It should not be forgotten that although the terms of reference for Mark Ellison KC, who first investigated the SDS, were limited, what he discovered from the information at his disposal, which was limited, raised concerns about the SDS that went far wider. The evidence before this inquiry raises significant concerns that go even further. The primary purpose of this inquiry is to establish, quote, justice for the families and victims and make recommendations for future operations and policing practice. However, in doing so, this inquiry must also play a fundamental role in repairing the damage caused by undercover policing, to restore public trust and ensure that the public and the state understand what went wrong and why, so that the right lessons are learnt. The findings of this inquiry for Tranche 1 could not come at a more important time in both the United Kingdom and around the world. This inquiry and you, sir, have a unique and privileged opportunity to inform the future of undercover policing and public debate. This is no small task. For example, in the last few weeks, it has emerged that Spain is facing its own undercover policing scandal. It seems that 2 undercover police officers have recently been identified infiltrating various groups considered to be on the political left, and 1 had at least 8 sexual relationships with women. So the world is watching this inquiry. In this country, as you know, public trust and confidence in policing, and in the Metropolitan Police Service in particular, is at an all-time low. The Metropolitan Police Service as an institution has already been found to be institutionally racist and corrupt, and marred by a culture of toxic masculinity, misogyny, sexual harassment, and rape. Much of the misogyny that still affects policing today, particularly in the Metropolitan Police Service, has its roots in the history of their policing and the abhorrent practices and culture that infected the Metropolitan Police Service during and following the Tranche 1 era. This has been powerfully and comprehensively demonstrated to be the case in the written and oral submissions submitted on behalf of Category H, which you heard yesterday. Against this background, there is widespread concern about the future of undercover policing. The Covert Human Intelligence Sources Criminal Conduct Act 2021 received royal assent on the 1st of March 2021. The CHIS Act, as it's colloquially known, provides for an express power to authorise undercover law enforcement agents to commit crimes, including those of the most serious nature, in the undertaking of their duties. The available justifications for criminal activities provided by the statute include the prevention or detection of crime or prevention of disorder, and necessity in the interests of the economic well-being of the United Kingdom. The serious abuses that the non-police state corps participants have experienced at the hands of undercover police officers are a stark reminder of the potential consequences of the expansion of covert surveillance powers without sufficient accountability. Against this background, it's even more important that the inquiry fully and fearlessly exposes what went wrong within the Metropolitan Police Service and the SDS and why, so that the correct lessons are learnt from Tranche 1. The starting point in restoring public trust is that the state and the police must acknowledge the indisputable unlawfulness and illegitimacy of the SDS and its undercover operations and open itself up to honest public scrutiny and accountability. So far in this inquiry, the police have gone to great lengths to restrict and hide from public view the names and identities of former SDS police officers and managers, together with huge swathes of information, including the names of many of the groups spied upon by the SDS. The non-police state corps participants note that recently 2 relatives of a deceased child whose identities were stolen by the SDS undercovers also had their identities restricted. The non-police state corps participants are aware, sir, that you have been challenged in the courts. We do not know who has challenged you, but we are fairly certain any challenges were brought to further restrict the disclosure available for public scrutiny in this inquiry. Of note, the non-police state corps participants do not know the full extent to which the Home Office has sought to restrict information disclosed to this inquiry. Now that the evidence has concluded for Tranche 1, it is deeply concerning and regrettable that certain parts of the state are still no closer to fully acknowledging what went wrong and why. The non-police state corps participants and the public have still not been provided with fulsome and unqualified apologies. It is not correct to assert as the Home Office do, that they had limited direct involvement with the SDS in Tranche 1. The Home Office funded and approved the establishment of the SDS. Not only that, senior Home Office officials allowed the SDS to continue whilst fully appreciating that the vast majority of its operations were unjustified and potentially unlawful. Despite this, the Home Office is still refusing to publicly accept responsibility for what the SDS did in Tranche 1. Rather, the Home Office seeks to distance itself from the worst behaviours of SDS undercovers by claiming that it did not know what was going on. So the Home Office was the relevant police authority for the Metropolitan Police Service. It is not good enough for it to simply say that politicians and Home Office civil servants were blind to the worst excesses of the SDS. The non-police state corps participants remain sceptical and believe that the Home Office and its employees knew and know a lot more than it is willing to admit or disclose. However, if this really is the position, then, sir, you should make it clear that this was a catastrophic failure of governance by the Home Office. Either way, this inquiry should condemn the use by the Home Office of this tactic of plausible deniability. In terms of the Metropolitan Police Service, the non-police state corps participants were disappointed to read their closing submissions. There is no getting away from the fact that the Metropolitan Police Service is still seeking to defend the SDS and much of its undercover operations. As we have heard, the Metropolitan Police Service is disputing the independent view of your counsel to the inquiry and is seeking to persuade you, sir, that you cannot make clear findings on the lawful justification for the SDS and its undercover operations. We urge you to reject these submissions. They are simply wrong for all the reasons we and your counsel to the inquiry have already set out in written submissions. As we've heard, sir, the Metropolitan Police Service is also still refusing to provide a fulsome and unqualified apology for all aspects of SDS undercover operations and reporting. The non-police state corps participants therefore call on the government, including the Home Office, the Security Service and the Metropolitan Police Service, to formally admit and take responsibility for all the abuses of fundamental human and democratic rights that occurred at the hands of the SDS. This must also include an acknowledgement of the devastating and lasting effect the SDS has had on individuals, members of the public and British democracy. The non-police state corps participants also call on the government, the Home Office, the Security Services and the Metropolitan Police Service to reconsider their attempts to restrict the public scrutiny of documents before this inquiry as it moves to later tranches. So ensuring accountability, and in the words of Theresa May, quote, the greatest possible scrutiny into what has taken place. So this will require you to be bold and robust in recording and identifying precisely what went wrong and why. So you will need to make clear findings on where responsibility lies, including at the highest political levels. You will need to be so very clear in identifying the political influence exercised not only by the Home Office, but crucially by the Cabinet Office and other government departments, and their combined role in facilitating the establishment of the SDS and maintaining its secrecy. This must also include findings in relation to the influence and role played by the Security Service in seeking to outsource key tasks to an unaccountable policing unit. It must also include an analysis of what was known by the various prime ministers of the day. So this inquiry has so far declined to investigate the office of the Prime Minister. It is inconceivable that the fact of the SDS and the nature of its undercover operations was not known about and sanctioned by each Prime Minister in Tranche 1. Establishing the state of knowledge of His Majesty's government is a requirement of the terms of reference. This must include the Prime Minister's in post at the relevant time. It is therefore essential that this inquiry follows the chain of knowledge about the SDS and its successor unit, the MPOIU, all the way to the top. This is an area that will need to be robustly explored by the inquiry in Tranche 2. So, as you know, the unashamedly political policing practices of the SDS and its successor unit, the MPOIU, continued for at least 40 years. It therefore came as some surprise to the non-police state corps participants when they read the Metropolitan Police Service's closing submissions and the assertion that SDS undercover operations, quote, would not occur now applying modern policing standards and under the current legal and policy framework post-RIPA, and that by modern standards, the SDS deployments in this period are unjustifiable, end of quotes. As you know, sir, the abhorrent practices from Tranche 1 did survive the passing into law of the regulation of the Introductory Powers Act 2000. Regulation made no difference. The non-police state corps participants consider that in these Tranche 1 closing submissions, the Metropolitan Police Service have now finally accepted that the MPOIU and its undercover operations were unjustifiable, and that unit should have been disbanded. The non-police state corps participants hope that this admission will inform the Metropolitan Police Service's approach to Tranche 2. The non-police state corps participants have always suspected and maintained that the SDS was not fundamentally about managing and policing public disorder or detecting or combating crime. Rather, it was a political policing unit that was dominated at times by the demands of the security service and heavily influenced by governmental paranoia about so-called subversion and the political left. The non-police state corps participants maintain that this provides the true explanation as to why the SDS was allowed to continue and why the abhorrent practices flourished long after Tranche 1. At the conclusion of the evidence, the non-police state corps participants have been vindicated and shown to be right. The disclosure before this inquiry puts beyond any doubt that from the outset, the SDS was deliberately and knowingly designed to be a secret policing unit to avoid independent democratic scrutiny and oversight. The Home Office and Home Secretaries in Tranche 1 not only knew this fact, but they also made clear that the funding and survival of the SDS was contingent upon the total secrecy to avoid political embarrassment. Not only that, as you will know, sir, decisions were taken by certain senior civil servants to conceal the existence of the SDS, whilst at the same time, the public were being reassured that any surveillance, including data collection of those politically active on the left, did not happen. At the same time, police managers within the MPS and SDS knew, encouraged and covered up obviously unlawful conduct and misconduct by undercover officers and misled the courts. They developed abhorrent tradecraft practices which became embedded within the SDS and the MPOIU. Secrecy prevailed above all else, including the rule of law. There was no adequate system of operational governance or oversight of the SDS at any level, including operational governance of the SDS by the Home Office, the Metropolitan Police Service, and by the SDS managers. Her Majesty, or His Majesty's Chief Inspector of Constabulary, failed to provide independent oversight and at times went even further than the police, ensuring that Special Branch and the SDS activities remained shielded from scrutiny. So you are therefore requested to unequivocally find that from the moment of its inception, the SDS was an unjustified and profoundly anti-democratic undercover policing unit, and that senior politicians, civil servants, and senior police officers realised at the time that what they were doing probably did not have any lawful justification. You are also requested to find that SDS operations were motivated by political and economic objectives, and targeted civil society on the political left wing, and in doing so, attacked, undermined, and violated the fundamental and democratic rights of citizens to engage in freedom of expression, political thought, assembly, and association. Sir, you're also asked to recognise and record that there were many missed opportunities and occasions when the state could and should have revealed the existence of the SDS to ensure wider public scrutiny. The non-police state corps participants assert that if this had happened, the SDS would have been disbanded. So the failure to take such steps has led to yet more devastation and trauma for a wide range of individuals and groups whose voices are still to be heard by this inquiry. It's also important, sir, that you acknowledge that those targeted by the SDS were not subversive. They were simply exercising their fundamental human and democratic rights, which were protected in law. These rights were enshrined in law precisely because Parliament and the courts recognised that individuals exercising such rights needed protection, often against the state and those seeking to preserve the status quo. It also ought to be recognised that it was the job of the police to protect such rights and enforce the law in the face of pressure from the government of the day. The judgment of the Investigatory Powers Tribunal in the Kate Wilson case puts beyond doubt that the type of undercover policing operations used by the SDS and later units violated these fundamental human rights, including the right not to be subject to inhuman and degrading treatment, the right to private and family life, and freedoms of expression, assembly, and association. Finally, sir, we also ask you to reflect on the fact that the non-police state corps participants, put simply, were on the right side of history in their campaigns against, for example, apartheid, racism, sexism, blacklisting, and the fight for trade union rights and adequate pay, protection of the environment and animals, and police accountability. So I now want to deal with missed opportunities briefly. There were a number of key watershed moments in the Tranche 1 era when there were crucial missed opportunities for members of the government, Whitehall, and the MPS to review and disband the SDS and bring an end to its methods and tradecraft. The non-police state corps participants contend that the fact that this did not happen is highly significant. The missed opportunities and how the state responded to those moments must remain at the front and centre of your mind when considering the findings for Tranche 1. This is because they will give you a valuable insight into the reasons why the SDS was able to exist for so long. They also begin to illustrate the extent to which institutions of the state either turned a blind eye to the SDS or were deliberately complicit in shielding the unit from public scrutiny. The first missed opportunity was the Lord Scarman public inquiry into the public disorder at Red Lion Square on the 15th of June 1974. The events at Red Lion Square on this day are of huge significance to the non-police state corps participants. One of the demonstrators, Kevin Gately, died. Policing tactics adopted on the day, including the deployment of the Special Patrol Group, were used at subsequent demonstrations, including in Southall in 1979, when Blair Peach was killed following a blow to the head from an SPG officer. The events are also of significance to this inquiry, which is concerned with judicial oversight of undercover policing. The non-police state corps participants in their written closing submissions have provided the inquiry with a document located in the National Archives by the Undercover Research Group. This document appears to show that prior to or during the public inquiry, Lord Scarman was told about the methods used by the SDS in a note and then in a private discussion, and then he was asked not to reveal these messages in the inquiry. The document speaks for itself, so I'll read it out. Could I ask, please, for the inquiry to put the document up on screen? It's Doc 110, thank you. And if we could just go to the first page. So as we can see from the first page, this is an undated document and it's self-explanatory, but it relates to the Red Lion Square inquiry. There's a bundle of documents which contain notes of meetings, and as we can see, it remained closed and secret until 2005. So if we could just go over to the next page, please. So this is the document that I'm just going to read into the record. It's entitled Confidential, and it's a note or a letter from a Mr. Belfile to DHJ Hillary, from DHJ Hillary of F4 Division. And just so that we're clear, Mr. Belfile was the secretary of the Red Lion Square inquiry, and it says as follows: Mr. Belfile, as I've mentioned to you, plainclothes police officers get information about demonstrations and extremist organisations by methods which it is essential should not be revealed. The police files about the Red Lion Square demonstration contain references to these methods. Sir Arthur Peterson has instructed me to indicate this difficulty to Lord Justice Scarman, and I should be grateful if you would place this note before him. I have also mentioned the difficulty to Sir Henry Ware. So just pausing there, just for the record, in case others don't know, Sir Arthur Peterson was the permanent Under Secretary of State at the Home Office at this time, and we understand Sir Henry Ware was the Treasury Solicitor. And the note goes on. The Solicitor to the Metropolitan Police is seeing the Deputy Treasury Solicitor at noon tomorrow and will discuss the matter then. Mr. Hall will then be able to inform Lord Justice Scarman, of the difficulty in greater detail. And as I've said, it's signed off DHJ Hillary of F4 Division of the Metropolitan, which is the Metropolitan Police Service. Thank you very much. We can take that down now. So as you can see, sir,
forgive me for interrupting you, Ms. Heaven, but this document is you've put this in, and this is the first time that it's been discussed. It is not clear from the language that the author is referring to the SDS. It is not. The language is consistent with him referring to the SDS, to the gathering of intelligence by other means available to Special Branch traditionally, or both.
Yes, sir. And I'm going to say some words about that, but I think that must be fair. So as you can see, so in 1974, the MPS and their solicitors, on direct instructions from a senior minister in the Home Office, and with the involvement of the Treasury Solicitor, who was the solicitor for this inquiry, he instigated a private briefing of Lord Scarman to persuade him to investigate the fact that, quote, plainclothes police officers get information about demonstrations and extremist organisations by methods which it is essential should not be revealed. The non-police state corps participants contend that the only sensible explanation is that this description must at the very least refer to the SDS, and of course it could relate as well to other methods, as you've just indicated. So no one could sensibly suggest that the SDS and its operations were not relevant to Lord Scarman's public inquiry into Red Lion Square. The presence of the SDS undercover officers and the nature of its undercover operations fell squarely within Lord Scarman's terms of reference, which were to review the events and actions which led to the disorder in Red Lion Square on the 15th of June, and to consider whether any lessons may be learned for the better maintenance of public order when demonstrations take place. As part of his inquiry, Lord Scarman was tasked not only with gathering eyewitness accounts, but also to understand whether lessons may be learnt in managing public order in the future. This was the apparent justification for the existence of the SDS. Surely, if the unit was not doing what it was tasked to do, Lord Scarman needed to know. So the document that I've just read out from the police files about Red Lion Square does suggest that the sensitive material is within the Red Lion Square file. Now, so coming on to the query or the point that you've just made, this inquiry knows that the SDS was targeting and reporting on groups present on the 15th of June 1974, prior to and during the protest in Red Lion Square. SDS undercover officers provided advance intelligence and, quote, gave forewarning of both the size of the demonstration and the possible disorder which might occur. HN 34 Geoffrey Kraft told this inquiry that he thought SDS intelligence made a difference to the police response on the day. At least 2 SDS officers were present on the day and witnessed what had happened, and one of those undercover officers was punched in the face by a police officer in uniform. And so this is why we say it's highly likely that at the very minimum, that Red Lion Square file would have contained information and documents from the SDS, and that the quote that I've read out must at least have included that material, if not other material and other tactics being used on that day as well. None of this was investigated by Lord Scarman in open proceedings. There is no suggestion in Lord Scarman's report of any closed session or closed material being given to the inquiry. This was a significant missed opportunity. Had Lord Scarman investigated the SDS may have been exposed. There is every possibility that the SDS would have been disbanded. No doubt, there would have been public exposure of how SDS intelligence made absolutely no difference to the police response on that day. Covering up the existence of the SDS would have been much more difficult following judicial scrutiny in a public inquiry. So the non-police state court participants have long suspected that the Metropolitan Police Service have deliberately destroyed key reporting and documentation relevant to what happened at the demonstrations in Red Lion Square and at Southall. The Metropolitan Police Service, Treasury Solicitor and Home Office have failed to disclose to this inquiry any information on their private briefings to Lord Scarman. The non-police state court participants asked the inquiry to request all relevant evidence on this issue. The inquiry is also requested to call evidence in Tranche 2 from Anthony Speed, in light of his liaison role to Lord Scarman and his comment in his witness statement to this inquiry that he would be surprised if Lord Scarman had not been told about the SDS. It is important, sir, that you establish so far as possible why Lord Scarman did not investigate the SDS. This is particularly so given the findings of Mark Ellis and KC in relation to the Stephen Lawrence inquiry, a public inquiry that was not told about the SDS. Questions must be asked and answered about the extent to which the SDS was protected from public scrutiny in yet another public inquiry and who was complicit in this. The second missed opportunity came with the circulation of the Special Branch report, Political Extremism and the Campaign for Police Accountability within the Metropolitan District in January 1983. The Police Accountability Report is a special branch report by C Squad that evidences the targeting and reporting on the elected leadership of the Greater London Council and justice and defence organisations campaigning for police accountability within the London area. So the non-police state court participants endorse the comprehensive critique of this document set out yesterday in the closing submissions made on behalf of Celia Stubbs. In brief, the Police Accountability Report is a significant document in scope and size, totalling 100 pages. It contains extensive personal and financial information, including information about the Greater London Council and key individuals, some of whom are core participants in this inquiry, such as Ken Livingstone. The report triggered outrage in the Home Office and clearly represented a crucial opportunity for senior Home Office civil servants to rein in the Metropolitan Police Special Branch and ask crucial questions about the undercover operations of the SDS and the uses of its intelligence. There are clear examples where this Police Accountability Report refers to SDS reporting and, quote, secret sources. However, the real significance of the Police Accountability Report is that it puts the Home Office on notice as to just how far the Metropolitan Police Service was willing to go to protect itself. Despite this, the Home Office continued to fund a secret and unaccountable Metropolitan Police spying unit with no or few questions asked. This was a significant missed opportunity in the history of the SDS. There is now substantial evidence before the inquiry on the extent to which the Special Branch were willing to engage in unlawful state surveillance and utilise the SDS in targeting campaigns seeking justice and police accountability under the mantle of so-called subversion. Not only must this be reflected in your findings for Tranche 1, the inquiry must now explore in Tranche 2 the implications of the Police Accountability Report and the apparent intention of the Metropolitan Police Service to set up a police accountability monitoring unit within the force. The inquiry must investigate whether there is any connection between this monitoring unit and the targeting of police accountability campaigns in Tranche 1 and Tranche 3 and beyond, including Category G, the family of Stephen Lawrence, Dwayne Brooks, OBE, and Michael Mansfield, KC. The third missed opportunity is the report and the draft report of the Home Affairs Select Committee into special branches of the 23rd of January 1985. The Home Affairs Select Committee investigation provided a crucial opportunity for the Home Office and the NPS to be honest about their activities and open themselves up to democratic scrutiny and accountability in relation to the SDS. It is a matter of historical fact that the final committee report recorded that public anxiety about the work of special branches in England and Wales was not justified. Claire Short MP and Mr David Winnick MP, both of whom are still alive, came to a different view. They prepared a draft report making clear that in their view they were satisfied, quote, that political surveillance is carried out by the special branches, often at the request of the intelligence services, against those who in no way wish to undermine or destroy parliamentary democracy or threaten the well-being of the state. Now, counsel to the inquiry have stated in their closing submissions that parliamentary privilege prevents you from making critical findings on the evidence given to the Home Affairs Select Committee. However, the Home Affairs Select Committee is of real significance to this inquiry. And as you know, sir, the non-police state court participants have legitimate concerns arising from the disclosure of the Home Affairs Select Committee papers. So given the importance of this issue to your terms of reference, and given the fact that it actually falls after the Tranche 1 period, the non-police state court participants propose that this issue is dealt with in slower time in Tranche 2. But sir, at this stage, we note the following. It is not a breach of parliamentary privilege for you to record and make reference to parliamentary proceedings as undisputed proof of a historical fact. And for your reference, sir, this can be found in Erskine May at paragraph 1618 to 1622. The non-police state court participants ask that you do not completely disregard and exclude from your mind what you have read and know to be true. It is a matter of historical fact that the existence of the SDS and its undercover operations does not appear in the evidence given to the Home Affairs Select Committee. So if you're in any doubt about this historical fact, then an obvious step would be to obtain witness evidence from Claire Short and David Winnick so that they can tell this inquiry what, if anything, they knew about the SDS and its methods during Tranche 1 and Tranche 2. As has been stated by counsel to the inquiry in their closing submissions for Tranche 1, the concerns raised within the Home Office about the counter-subversion work of special branches' role represented a missed opportunity to act on those concerns. So this opportunity was missed largely because the Home Office, under some influence from the Security Service, was preoccupied with covering up the problematic state surveillance of so-called potentially subversive individuals by special branch. The documents show that the Home Office wanted to ensure that special branches could continue with this work. the duplicitous approach taken by the Home Office to the redrafting of the 1970 Special Branch Terms of Reference, which became the 1984 guidelines, is linked in various ways to the Home Affairs Select Committee. These are all matters upon which the non-police state corps participants will wish to make further submissions in advance of Tranche 2. Now, so I just want to say very few words on each of the specific aspects of your terms of reference. As you know, so detailed written closing submissions suggest to you that you should make a number of factual findings as being open to you on the evidence in respect of Tranche 1. I will read some of those suggested findings shortly with a brief explanation, time permitting. But just by way of general comments, sir, the non-police state corps participants ask you to record as many of these factual findings as possible, or findings of a similar nature, however you choose to express them. You're also asked to reflect the findings contended for by other non-state corps participant categories who've made detailed written and oral representations. You will understand, sir, that the non-police state corps participants have been waiting a very long time for answers and accountability, and it's therefore important that findings are as detailed as possible. So the non-police state corps participants contend that the following findings are supported by the evidence before this inquiry in Tranche 1. In terms of motivation for undercover policing operations, and these are the findings the non-police state corps participants asked you to record. The SDS was established so that the state could monitor and record the exercise of fundamental human democratic rights, including freedoms of expression and political thought, of assembly and political association of members of the public. So you do have these in our written document, just so you know. The individuals and groups targeted by the SDS were largely on the political left wing and or perceived to be on the political left wing. They were targeted because of their beliefs and activities, as opposed to any real subversive threat and or participation in serious crime. The SDS was not a rogue unit, it was a political policing unit that came under the umbrella of the wider secret state. The SDS activities were motivated by political and economic objectives rather than any lawfully justifiable, legitimate policing purpose. And so just by way of brief explanation, we've discussed in our written submissions the history of political policing in the United Kingdom, and we've referred you to what we say is an important book written by a corps participant, Tony Bunyan, on the history of and practice of the political police in Britain. So as you will of course appreciate, the history of political policing is important in the context of this inquiry. Undercover political policing and the secret state did not suddenly come into existence in 1968. State powers have been used as early as 1790s to target groups and individuals threatening to disrupt the political status quo. The Metropolitan Police Special Branch predates the formation of MI5 in 1909. And in the era prior to Tranche 1, Metropolitan Police Special Branch led the way in targeting and monitoring of so-called subversive elements in British society. The Metropolitan Police Special Branch has always been well integrated and a leader within the secret state. The politics and the lie behind the creation of the SDS have been comprehensively dealt with in both the opening and closing submissions made by Mr. Rajiv Menon KC on behalf of Tariq Ali, Ernie Tate and Piers Corbyn. We simply add that the SDS from the moment of its creation was not politically neutral. The election of Ted Heath heralded an intensifying political paranoia around subversion, which was often in the documents found lacking by civil servants. In a statement of the security service witness said to this inquiry, we learn that the pressure to investigate subversive organisations, quote, often came from the Prime Minister and Whitehall. The Cabinet Office documents recently disclosed to this inquiry and to the corps participants show that the SDS, whilst the brainchild of Conrad Dixon, was highly likely to have been considered and co-opted as part of a broader campaign to counter subversion in the United Kingdom. In the words of your counsel to the inquiry, which we endorse, the SDS did not operate in a vacuum, nor was it a rogue unit. It was one part of a larger intelligence gathering apparatus, which gathered intelligence about political activities on what was termed the extreme left. Now, so I just want to briefly touch upon the findings that we ask you to make on the scope of undercover policings, and they are as follows, and they are replicated in our written document. SDS undercover policing operations targeted and had an impact on members of the public across England and Wales. Police spies from the SDS used false and stolen identities to invade private homes, violate the intimacy of private life and personal lives, and to inveigle their way into personal and private dealings of individuals, groups, and communities. In Tranche 1, there's evidence that the SDS intentionally targeted the following groups and individuals, and that this was known about and sanctioned by managers: political organisations and politicians, trade unions and trade union members, justice and defence campaigns, including campaigns focused on police accountability, lawyers, children, political activists, and social and environmental activists. I'll come on in a moment to just say a few brief words in relation to each of those groups. But before I do that, I'll just summarise the propositions in relation to the effect of undercover policing. So we ask you to consider making findings along these lines. As a direct and indirect result of SDS undercover operations, the state interfered with and disrupted the exercise of fundamental human and democratic rights by members of the public. These fundamental human and democratic rights and the impact on those rights were rarely, if ever, considered by politicians and senior civil servants in government, including the Home Office, Cabinet Office, by the Security Service, senior police officers in the Metropolitan Police Service, or SDS managers. The SDS gathered vast quantities of data, including highly confidential information about people's private lives and their relationships, including medical and financial information and information relating to membership of and support for political organisations and groups. The data was stored in police files and shared with the Security Service, employers, and other shadowy customers, government agencies, and private entities. There was no consideration as to whether this information was relevant to SDS operations or the right to privacy. SDS state-sponsored espionage had a devastating and lasting impact on society, individual members of the public, their communities, and families of undercover officers. Lives and livelihoods were destroyed. The identities of dead children were stolen, leading to deep trauma for bereaved families. Members of the public were assaulted and betrayed into false, intimate personal relationships, including being deceived into having sexual intercourse and intimate contact with undercover officers without informed consent. Bereaved individuals campaigning for justice and those defending their rights, often against police abuses, were deliberately targeted and had their campaigns and right to legal advice violated. Courts were misled and the justice system was undermined. Groups and individuals exercising their democratic rights were interfered with and disrupted. The Metropolitan Police Service, through the SDS, established policing practices and tradecraft that were criminal, unlawful, and abhorrent, and these practices went unchallenged for at least 40 years. Democracy, policing legitimacy, and public trust have been undermined by the SDS, and there have been continued attempts by the MPS and certain branches of the state to conceal the true nature and extent of SDS operations and SDS tradecraft. So the effect of SDS undercover policing operations on certain non-state core participants has been set out in a number of opening and closing statements to this inquiry. You've also heard some oral evidence and received some witness statements. However, the reality is that there are many individuals and members of the public who have been affected by SDS undercover policing, whose voices have not and will not be heard. It is hoped that in Tranche 2, the inquiry will seek to hear as many of these voices as possible. So I've already largely dealt with His Majesty's Government's state of awareness in my introduction, but the finding, I'll just read it out, that we have submitted to you in writing is as follows. The SDS was known about by Home Secretaries and senior civil servants holding office in Tranche 1, and it's inconceivable that successive Prime Ministers during Tranche 1 did not know about the SDS. I'll now turn to the issue of justification of undercover policing. So you must address the issue of lawfulness for all the reasons set out on behalf of the Category H core participants yesterday, and I won't repeat them now. However, it is important for me to make clear today that the non-police state core participants agree and endorse your counsel to the inquiry's view, which has been set out in some detail, but in particular, I want to emphasise what is said about lawfulness of SDS operations being relevant to your terms of reference, and it's as follows. Whether the methods used by undercover police officers were lawful is relevant to whether or not their work was justified, and to whether authorisation, operational governance, training, management and oversight were adequate. Similarly, if undercover policing was being conducted in an unlawful manner, it will call into question the adequacy of statutory and policy guidance in particular. So the Metropolitan Police Service and the designated, those who represent the designated officers in particular have gone to great efforts to emphasise the public order aspect of SDS undercover operations. There is, as you know, a large measure of disagreement as to the extent to which the SDS was in fact concerned with public order. The non-police state core participants in their analysis of the reporting have struggled to find anything more than a tiny minority of reports that could be said to be tangentially relevant to public order. In any event, in respect of public order justification, the non-police state core participants agree with your counsel to the inquiry's closing submissions, namely that, quote, the need for and value of the public order intelligence provided by the SDS was not an adequate justification for the intrusion caused by the SDS model of long-term undercover policing in the Tranche 1 era. In respect of the subversion justification, the non-police state core participants also agree with your counsel to the inquiry's closing submissions, namely that, quote, the groups infiltrated by the SDS were not subversive, and that, quote, there is a strong case for concluding that they should have decided to disband the SDS. So on this latter issue of justification and subversion, the non-police state core participants just remind you of what appears in the contemporaneous Home Office disclosure. And you don't need to look at very much of this, we say, on this topic. In short, the disclosure shows you that the permanent Under-Secretary of State at the Home Office, and this individual was funding the SDS at the time, was told in 1980, quote, neither the present definition of subversion nor the 1970 terms of reference provide ministers or chief officers with a watertight basis on which to justify the work of police officers investigating and recording the activity of subversives. So I mentioned Home Office accountability at the start of these submissions. The quotation that I've just read out constitutes, in the non-police state core participants submission, very clear evidence that senior Home Office civil servants were on notice that the SDS was probably engaging in unlawful and unjustified police surveillance during the whole of the Tranche 1 period. And what we know from the evidence is, on being told that, no steps were taken to disband or even investigate the SDS. The non-police state core participants therefore ask you to make the following findings. We want you to find the findings that I've already read out from your counsel to the inquiry. And alongside that, we ask you to find the following. There was insufficient justification for the establishment of the SDS and for SDS undercover policing operations between 1969 to 1982. Senior ministers and civil servants in the Home Office knew that the Metropolitan Police Service, through the SDS, was engaged in police surveillance work that was deeply problematic and probably not legally justifiable. Despite this, senior ministers and civil servants and politicians in the Home Office and senior Metropolitan Police officers did not consider the lawfulness of SDS operations, the legal rights of activists subject to surveillance, or the effect and consequences of the type of secret policing and tradecraft being conducted by the SDS. SDS managers also gave these issues scant, if any, consideration. And then finally, the state deliberately took a duplicitous and secretive approach to redrafting the special branch terms of reference or guidelines to ensure the continuation of unlawful state surveillance operations such as those being conducted by the SDS. So very briefly, in the context of justification, I'll just make a few discrete points. The Metropolitan Police Service in their closing submissions placed significant emphasis during the Tranche 1 era on the so-called British policing model, which was described as striking a balance in the protection of rights that was more effective and more appropriate when compared to the model used in America. The Metropolitan Police Service suggests that this reflects the value of the SDS for public order policing. So we simply remind you that there is documentary evidence before the inquiry that in Tranche 1, the Federal Bureau of Investigation's FBI in America and the Royal Canadian Mounted Police were exposed in the Tranche 1 era for using covert surveillance policing tactics on the political left that were similar and in some cases identical to those being used by the SDS. We can also see that those with managerial responsibility for the SDS in Tranche 1 were well aware that these policing tactics of their allies had been found to be unlawful, anti-democratic and illegitimate in a Western democracy in Tranche 1. Those same managers are on record in Tranche 1 expressing their worries and concerns that there could be similar exposure of their own policing tactics. These international examples are relevant, sir, as they do tend to run counter to the general defence of the SDS as put forward by the MPS and DL officers. In particular, the concept that rights were very different in Tranche 1, or that covert surveillance tactics on the left would not be called out as controversial for contemporaneous public policy reasons. So these examples in particular show you that these arguments are not borne out by what had happened in America and Canada in the mid-1970s, which was, of course, at the height of the Cold War. So I now turn to the adequacy of authorisation and targeting of undercover policing. The non-police state corps participants ask you to make the following findings. The actions of the SDS were not subject to any of the strict controls as required by law for the type of surveillance engaged in by the SDS. Decision-making and the authorisation of targeting was subject to inadequate managerial control, both within the SDS and by the senior MPS police officers. SDS managers did not review the necessity or proportionality of SDS operations and deployments. Either before or during the deployment, feedback was not sought. SDS and its targeting was influenced by demands from outside the SDS, including from the Security Service, the wider Special Branch, the Metropolitan Police Service and other government agencies. Now, the non-police state corps participants' written submissions deal with the external influences on SDS operations, including from the Security Service. And one example of abhorrent targeting and reporting that we've identified, as you know, relates to children. And you'll recall the footage from the School Kids Against the Nazis that we played in our opening submissions in Tranche 1 Phase 2. You will have heard the submissions made on behalf of the DL officers about there being nothing wrong with police officers targeting and reporting on children and schools where they were being targeted by left-wing extremists. The Metropolitan Police Service now suggests in their closing submissions that children were reported on, but it was for, quote, safeguarding or vulnerability assessments. the MPS made the general submission on Monday that you should not judge the SDS by reference to the so-called modern era. However, this is exactly what the MPS is now doing in relation to reporting on children. There is no evidence to suggest children were being reported on in Tranche 1 for safeguarding or vulnerability reasons. In fact, many would say there was no concept of safeguarding and vulnerability in the Tranche 1 era. After all, this was before the introduction of the Children Act 1989. In fact, the protection of children appears to have been of little concern. Children are routinely described in disparaging ways in SDS reporting, and of course there's no reference to the Metropolitan Police Service of the fact that undercover officers were babysitting for children when undercover. The non-police state core participants query why, after all this time, the MPS is still attempting to justify what is plainly abhorrent and disproportionate reporting of children. This is unfortunately an example of how the MPS still appears to be trying to excuse some of the actions of the SDS. The inquiry can now see that children, schools, educational facilities, they were all not being targeted because of some concern for child radicalisation. Rather, it was the influence of the security services that noted this targeting. However, there's no evidence to suggest that senior officers or SDS managers ever questioned why schools, school children, teachers, and higher education were deemed to be subversive. This was surely a common sense inquiry. Not to make it was a significant failing by SDS managers. The inquiry can now see that the security service did in fact have some difficulty themselves in finding any actual subversion in education. Their 1972 document, Subversion in the UK, for example, includes references to dons exerting their subversive views in an influential way, and the influence by unions on working conditions and pay in education, with the admission that, quote, the extent of subversive activities at school level is negligible. Had the SDS managers asked the security services about subversion in education, then presumably this is what they would have been told. So I'll now briefly deal with targeting under a number of topics. The first is targeting of social justice and defence campaigns. During Tranche 1, the MPS developed a tradecraft to monitor justice campaigns, including defence campaigns and those campaigning for police accountability, which we know continues into Tranche 2 and later tranches. The practice started almost as soon as the SDS was created, with the vast majority of groups involved in some element of anti-racism campaigning, and in particular with a focus on police racism and or brutality and police accountability. By way of very limited example, we see the Black Defence Committee, the Stephen McCarthy campaign from 1971, the Stoke Newington 8 Defence Group in 1972. The Stephen McCarthy case is the first example before the inquiry of the targeting of a justice campaign arising from a death following police contact. By 1983, the organisation Inquest, which was set up to campaign for truth, justice and accountability in respect of deaths in custody, appears in the Police Accountability Report into the Greater London Council. SDS interest in justice, defence and police accountability campaigns highlights that the focus of the SDS was not on serious crime, but more about the political objectives of the groups reported on, and in particular, campaigners who sought to discredit or criticise the police. Intelligence was not just collected as a result of, quote, collateral intrusion, as has been suggested by some undercover officers. The SDS annual reports show that many groups were purposefully targeted, for example, to name a few, the Action Bangladesh and the Afro-Asian American Association, ELWA, the Murray Defence Group, the Hackney and Tower Hamlets Defence Committee, Persons Unknown, the Newham Defence Committee, the Greenwich Action Committee Against Racist Attacks, and the South East London Action Committee Against Racist Attacks, the Brixton Defence Committee. Groups such as the Stoke Newington and Hackney Defence Campaign were listed as groups that were, quote, directly penetrated or closely monitored. A number of campaigns and individuals also had special branch registry files and featured in SDS reporting, including, as you heard yesterday, the Blair Peach campaign. We therefore ask you, sir, to consider making the following finding. Senior MPS and SDS managers knew about and authorised the targeting and infiltration of and gathering of intelligence about justice campaigns, including defence campaigns and those campaigning for police accountability in order to gain a litigation advantage, sow discord, shield the police from criticism and to disrupt the lawful and legitimate activity of such groups. Senior MPS and SDS managers gave no consideration to the possible impact of gathering intelligence in this way on legitimate justice, defence and police accountability campaigns and campaigners. I now want to turn to the targeting of members of parliament and other elected politicians very briefly. There are many examples of SDS undercover officers reporting on elected politicians within the material disclosed to the inquiry. One of the most egregious examples relates to HM155 Phil Cooper, who infiltrated the Right to Work campaign and obtained private documents and correspondence relating to the organisers, one of whom was a serving MP, Ernie Roberts. SDS manager HN68 Sean Lynch knew about this, and he noted to the security service that, quote, Cooper's position within the Right to Work movement gives him regular access to Ernie Roberts MP and meetings at the House of Commons, end of quote. But no action was taken to bring this situation to an end. Now, so the Wilson Doctrine had been introduced in 1966, and it would have been fresh in everyone's minds. It prohibited the phone tapping of MPs. However, what actually is the difference in practice between the tapping of an MP's phone and what HN155 was able to report on Ernie Roberts MP and his private conversations, should he so wish? There was no difference, and this would have been obvious to SDS managers. This one example, sir, gives you an insight into how these SDS managers saw themselves as above or exempt from the law and rules governing their conduct. So we ask you to find that senior MPS and SDS managers knew that SDS undercover officers were deployed in close proximity to elected politicians and, on one occasion, an MP in Parliament. They knew that SDS undercover officers had access to private dealings of MPs, elected representatives and political organisations, including mainstream political parties. And there is evidence of SDS reporting referencing MPs and that such MPs had Metropolitan Police Special Branch registry files. Senior MPS and SDS managers gave no consideration to the threat to democracy and the political and democratic process and the risk of the political democratic process of SDS undercover police officers gathering intelligence in close proximity to elected politicians and representatives and those involved in lawful political activity. They gave no consideration to whether in such circumstances the SDS was in breach of the Wilson Doctrine. Targeting of trade unions, sir. Just the following few short points. In Tranche 1, there is, quote, a growing focus on industrial issues, as referenced in the 1972 Special Branch Annual Report. And this forms a theme which runs on throughout the remainder of Tranche 1. HN 299342, David Hughes, notes that the perceived infiltration of trade unions and the Labour Party by extreme political groups was of concern to Special Branch and the Security Service. He described their work as follows. The SDS office would sometimes mention that senior MPS officers were meeting with the Security Service or the Home Secretary to discuss intelligence of this sort. I understand there was a lot of high-level cooperation in relation to subversion. Within the disclosure in this inquiry, there are numerous SDS reports providing detailed information about trade unions and their members. These include details of the organisational structure of trade unions, planned campaigns and events, and the response by political parties to anticipated strike action. For example, HN80 Colin Clark even reported on a meeting at which a play concerning trade union worker management participation schemes was performed. Detailed information was also recorded about specific individuals, including union affiliation, employers, participation in non-union campaigns, and the role of shop stewards. Much of the reporting focused on planned industrial action. HN 299342 David Hughes, who joined the Transport and General Workers Union, explained Special Branch were interested in the union due to concerns around, quote, entryism being employed by extreme political groups in organisations such as the T&G. HN 80 Colin Clark noted that information relating to tactics to be used at the Grunwick industrial dispute was of interest to Special Branch, as the dispute, quote, has significant public order implications, and so it and the groups involved were a focus for reporting. HM 126 Paul Gray stated that information about an individual's membership of the union was relevant to Special Branch and the security services, and an identified undercover officer described in closed session how they attended the industrial dispute at Grunwick about half a dozen times. They would go to, quote, gauge what the support was for the picket, and SDS managers were said to be pleased with the intelligence officers were providing. But HM 126 Paul Gray, whilst he denied in his witness statement that he was a key organiser at the Grunwick picket, he said something very different to his risk assessor. He said this to Brian Lockey about Grunwick, that, quote, SWP were a big part of the protests. I helped to organise the numbers and which days we're going to have a list of SWP, end of quote. So we ask you to find the following. Senior MPS and SDS managers knew about and authorised the gathering of intelligence about trade unions and trade union members. These actions were motivated by the fears of successive governments in Tranche 1 of the political influence of trade unions, especially their potential to challenge government policy, and a desire to gain intelligence about trade union influence and tactics within firms, including legitimate trade union disputes and their tactics. SDS intelligence gathered in this area was gathered to assist employers and the government to defeat legitimate trade union activity aimed at improving wages, terms and conditions. The policing establishment sought to shield the police from political criticism, and it is inconceivable that senior MPS and SDS managers were not aware that the surveillance of lawful and legitimate trade union activity was unjustifiable legally, politically and morally. SDS intelligence was deployed for wide-scale vetting and for blacklisting purposes. Now, in relation to this topic and vetting in particular, the non-police state core participants agree with your counsel to the inquiry that, quote, personal information recorded by SDS officers may have been used when files were later interrogated for vetting purposes. However, vetting occurred both before and after the SDS's existence. The level of intrusion into people's lives occasioned by SDS infiltrations does not seem to be justified by any additional relevant data that the SDS might have collected. It is certainly not a purpose which features prominently in the documents. In relation to blacklisting, the evidence before this inquiry reveals that the state agencies tasked with countering subversion deliberately disseminated intelligence gathered to external agencies. For example, a note on counter-subversion supplied by the Foreign and Commonwealth Office to Sir Burke Trend in 1971 states, the proposed coordinating group would analyse the problem as a whole and study the range of possible counter-subversion measures, including the dissemination and leakage of information at present practiced. A series of 3 documents record an exchange in late 1975, early 1976 between the Security Service and the Special Branch about their respective roles in the process. This demonstrates the widespread nature of the practice. One document describes the, quote, convention of passing, quote, security information about employees to certain employers. The relevant employers were described as government departments, public corporations, including the Atomic Energy Authority, Bank of England, British Airports Authority, British Airways, the Post Office Corporation, the BBC, the British Council, the National Research Development Council, and Crown agents for overseas governments and administrations, and List X companies. List X encompasses a wide range of employers, which the government defines as private corporations engaged in government security contracts. Between 1970 and 1973, the top 50 firms that held government defence contracts were all household names. They covered a range of sectors and included, for example, British Leyland, Rolls-Royce, Laird Group, British Steel, Shell, ICI, Weir Group, and Standard Telephones. The impact of this tradecraft was profound. The core participant, Richard Chesham, has given evidence to this inquiry as to how, despite his qualifications and decency, he was repeatedly refused employment. The Tranche 1, Phase 1 opening statement of Dave Smith on behalf of the Blacklist Support Group describes in detail the unimaginable emotional and financial toll that this practice took on those affected, including fellow blacklisted workers on the Jubilee extension line in the 1990s who took their own lives. As he said, quote, "No one can say that blacklisting was the sole reason for these suicides, but the prolonged periods of unemployment and family tensions cannot be good for anyone's mental health." In terms of specific examples, the inquiry knows that the SDS was tasked to spy on the Workers' Revolutionary Party, and in particular Roy Battersby. Intelligence was provided to the security services, who were expressly given the task of collating files in order to vet those seeking posts in sensitive government bodies, and as I've said, this included the BBC. Indeed, the BBC has confirmed and described this process. Roy Battersby, who was a BAFTA winner, has described in his statement to you how there is clear evidence that he was one of those blacklisted in the early to mid-1970s, despite having already won awards for his films Roll On 4 O'Clock and Leeds United. That Roy Battersby was blacklisted is now strengthened by what we see in the Tranche 1 disclosure. It clearly shows the obsession the security services had with so-called subversives in film and media, which at one point even extends to Ken Loach for his film Kes. And so you'll know we've set some more detailed submissions down in writing on the media in our closing submissions. Roy Battersby was by no means the only one to experience blacklisting connected to the SDS. As Roy Battersby states, this practice was an attack on the democratic process, privacy, and the freedoms of political and artistic expression, in particular, the plurality of voices and standpoints on our national broadcast for the BBC. So we ask you to find that no consideration was given to the lawfulness and the effect of SDS intelligence being used for wide-scale vetting and for blacklisting purposes. Vetting and blacklisting in reliance on SDS intelligence did occur in Tranche 1. So I'll now turn to the targeting of social and environmental activists. The disclosure in this inquiry is full of examples of the SDS targeting social and environmental activists in the Tranche 1 era, paving the way for what we know is going to be much more intensive surveillance in later years. I'll just read out very few examples of some of the groups targeted in Tranche 1. The Women's Liberation Front, the Women's National Coordinating Committee, the Women's Liberation Movement, the Revolutionary Women's Union, the National Abortion Campaign, St Pancras and Camden United Tenants Association, Hackney United Tenants Ad Hoc Committee, the Claimants Union, Gay Liberation Front and Preservation of the Rights of Prisoners campaign groups, the Battersea Redevelopment Action Group, and the Pavement Collective. The vast majority, if not all, of the reporting into activists focused on social issues and entirely legitimate democratic campaigning. Much of this reporting was signed off by SDS managers. So we therefore ask you to find that senior MPS and SDS managers knew about and authorised the targeting and infiltration and gathering of intelligence about social and environmental activist groups in order to disrupt and undermine the activity of such groups. Senior MPS and SDS managers gave no consideration to the possible impact of gathering intelligence in this way on social and environmental activists. So I now turn to the issue of race. The non-police state core participants remind you, sir, of the very powerful submissions made at the start of this inquiry from those non-police state core participants with direct experience of the institutionalised racism of the Metropolitan Police Service, SDS and the NPOIU. These submissions make reference to some of the most obvious examples of SDS reporting where racism and racist stereotypes and profiling are in evidence. Such attitudes clearly pervaded the MPS, Special Branch and the SDS in Tranche 1. This is, we submit, no surprise. It must not be forgotten that the MPS was branded as institutionally racist by Sir William Macpherson in 1999. That finding must not be diluted by this inquiry. Former MPS chief constables are on record in Tranche 1 displaying racist attitudes. For your reference, sir, you can find many examples of abhorrent attitudes on race in the autobiography of former MPS Commissioner Robert Mark, as referenced in our written submissions. A significant number of the campaigning individuals and organisations targeted by the SDS were Black justice campaigns. Consequently, it's essential that the role of racism in undercover policing is not misunderstood or unexplored. Race is a relevant factor in how campaigners were viewed by the state and the MPS. However, for the purpose of Tranche 1 findings, the non-police state core participants agree with counsel to the inquiry's suggestion that this is an issue that is best left for your final report once you've had the benefit of the full evidential picture for both the SDS and the NPOIU. So we do not ask you to make any findings on race in the interim report. I now turn to the adequacy of operational governance and oversight. In terms of operational governance, when Theresa May established this inquiry, she identified, quote, significant failings of judgment, intrusive supervision and leadership over a sustained period. The non-police state core participants agree. However, as we've already indicated, the failings go much further. And so these are what we ask you to record, sir. There was no adequate system of operational governance and oversight of the SDS at any level, including operational governance of the SDS by the Home Office, the NPS, and by SDS managers. This was because the SDS was deliberately designed to be a policing unit that operated in secret and without any independent scrutiny and oversight, to avoid political embarrassment and to ensure its survival. There was no formal mechanism for regular review of SDS practices by the Home Office. The 1970s terms of reference for Special Branch, under which the SDS operated, were woefully inadequate, deliberately vague, and conflicted with official definitions that sought to limit covert police surveillance. Senior MPS managers took no action to ensure robust governance of the SDS. There was only one formal review. The secrecy and security of SDS operations and the welfare of officers was prioritised over the rule of law, democratic accountability, the rights of members of the public and their obligations to the court. And then, so there are a number of findings, I'll just read them out briefly, which come under the heading of governance. The first relates to criminal offences. So we suggest you have sufficient evidence to find SDS undercover officers in their cover names committed criminal offences and then became involved in criminal proceedings and acted as agents provocateurs. Senior MPS and SDS managers knew and allowed this practice to occur in order to allow undercovers to maintain their cover, to protect the operational integrity of the SDS, and to avoid professional and political embarrassment to the MPS. Senior MPS and SDS managers gave no consideration to the potential impact on the fairness of criminal trials and the risk that their actions would lead to the miscarriage of justice. Numerous miscarriages of justice are likely to have occurred, and you've heard comprehensive submissions just a moment ago on this. on behalf of Lord Peter Hayne, Jonathan Rosenhead and Ernest Rodker. In respect of spying on lawyers, we ask you to find that senior MPS and SDS managers knew and were complicit in undercovers spying on lawyers and infringing legal professional privilege. And we've set out much more detail on that in our written closing submissions. Likewise, in respect of impunity for police brutality, we say that managers knew about and ignored violent and unlawful conduct by MPS police officers against SDS undercovers to maintain SDS cover. This reinforced a culture of impunity in respect of these acts of police brutality, and we've set out many examples in our closing submissions. We ask you to find that managers knew, encouraged, and covered up misconduct and criminal and unlawful conduct by undercovers, including burglary, driving when drunk, theft, and the misuse of drugs and alcohol. SDS managers did not consider SDS undercovers should be subject to disciplinary proceedings due to a risk of exposing the SDS. Again, we list all those examples in our closing submissions. It's also right that I say clearly in respect of category F and category H, we endorse the submissions in written and oral submissions that you've already heard in respect of those categories. In relation to selection, training, management and care of undercover officers, we ask you to find that there was no formal selection process for undercovers and most joined following informal recommendations. There was little or no guidance or training on any aspect of the undercover role, whether for managers or undercovers. And in relation to the adequacy of statutory policy or judicial regulation, we ask you to find that there was no statutory regulation of undercover policing and the type of surveillance and violation of rights arising from SDS surveillance, including the right to private and family life. Further, the SDS was consciously insulated and protected from any form of independent oversight and regulation, including by Parliament, the judicial system, or any other external regulatory body, including His Majesty's Chief Inspector of Constabulary. Now, finally, sir, and this is finally, I would like to finish on the topic of the role and the contribution made by undercover policing towards the prevention and detection of crime. So over the last few days, those who represent the Metropolitan Police Service and the former SDS police officers and managers have placed significant emphasis on public disorder in Tranche 1. So the non-police state corps participants were going to ask you to guard against these cynical attempts to flood your mind's eye with image after image of public disorder, much of which has no relevance to what you are tasked to consider. So such tactics are unhelpful to this inquiry. We were intending to remind you that you must make findings based on the evidence, and that this evidence in fact shows there is very little SDS reporting that could even tangentially be said to be relevant to public order, and that this is against a backdrop where you have been told that around 75 to 80% of SDS reporting went to the security service. And it is they, the security service, who have supplied much of the SDS reporting to this inquiry. However, sir, it's clear from your exchanges on Monday that you've already got this point. So the non-police state corps participants are grateful for the detailed and forensic work that you and your team have clearly undertaken. So on contribution, we would like to end with the words of HN 3093 Roy Creamer, who was one of the original founders and managers of the SDS. You may consider, sir, that having reflected on all of the evidence you heard from SDS managers in Tranche 1, Phase 3, that Roy Creamer was by a long shot the most insightful, the most honest, and the most credible of witnesses. He was obviously the least politically biased of all the SDS managers, and he was the only one who was willing to be honest with you about some of the problematic aspects of SDS tactics. Importantly, in terms of contribution, Roy Creamer was able to give you the perspective from both the SDS and then from the wider Special Branch and C Squad, where he spent a considerable period of Tranche 1. On SDS contribution, Roy Creamer told you, quote, "With demonstrations, it was a waste of time to look for deep-seated plans. It was difficult to assess all that, really. When the Yard expected Special Branch to come up with specific information, it was asking for the moon, and this could not be done. The SDS made an effort and did find out a lot of information. However, the idea that the SDS would find out and reveal plans was wishful thinking, I think." Thank you, sir.
Thank you very much. I'm sorry you had rather a hard task there.
But
Not
thank you.
only did you draw the graveyard slot, you also had to get through an enormous amount of ground, and I'm very grateful to you for doing so efficiently.
Thank you, sir. Thank you.